pay them an hourly rate, not likely that they're an independent contractor. The skill and initiative required in performing the job. Are they doing rote tasks for you? You know, they're always the one that runs the 11 o'clock trips, et cetera, or are they somebody who actually has some creativity to put into it and they bring their own skills? And the last thing is the permanency of the relationship. Now, this is where a lot of you get a little dodgy. You say, well, okay, you know, it's just a seasonal relationship. We don't employ them 12 months out of the year. But the truth is they're going to come back year after year, or you're the only one that they work for during that seasonal situation. You know, they're not working for somebody else. So permanency might not be the way that you use it. So when you think about, are they employees, are they not employees, think about this 5-part test. These are the things that you want to be careful of if the people are actually employees. You've got to meet your state statutory requirements for paying workers' compensation insurance. Workers' comp is a pool situation in all 50 states. You know, all you have to do if you don't know how to do it is call your DOL, tell them what the guy does. They'll actually give you an opinion right over the phone. The guy's an employee, he's not an employee. And you buy in numbers of employees. You've got to do your state and federal withholdings on these people. And then you have to consider Family Medical Leave Act, the Americans with Disabilities Act, particularly if they are more than seasonal employees. Do those things apply? If you really believe that these people are independent contractors, you want to 1099 them, you want to make sure that you report their wages, you want to require proof of liability insurance from them, that they are fully insured, that they're picking up their own, you know, medical and liability insurance if they're operating on your premises, because they could do something wrong. And if there's any doubt about the classification of the person, call DOL. So let's talk a little bit about screening employees. You know, in the lawsuits that we see, I can tell you that it is very, very common for there to be a claim or cause of action that sounds like this. It's going to come one of two ways. They're either going to say you didn't adequately train an employee, or you negligently hired the wrong employee. All right? And the way they get to that is just the inference or presumption that because there was an accident, somebody wasn't performing up to standards, and so the guy must not know what he's doing, and that's your fault, right, if you're the owner-operator. So it's important to screen employees. I mean, it's important for the liability of your operation. It's important to keep your other employees safe. It's important in how they handle clients. So we look at some things. You know, and I always want to go back to, what is negligence? It's failing to do what a reasonably prudent person would do, given whatever's going on, right? It's that process of trying to ascertain what's foreseeable here. So when you are operating as an employer, hiring somebody, you have to do what a reasonably prudent employer would do. Figure out who these people are. Right? Are they capable of doing whatever it is you want them to do? And that issue gets heightened the more responsibility you give them. I mean, it's one thing to have somebody sitting, you know, at the desk, and I'm not denigrating anybody who does the reservations or, you know, does the bookkeeping, but the minute you put that person behind the wheel with all your clients, right, or operating the raft, or, you know, taking them out in the background, I mean, obviously these things get a little bit heightened, right, when you expose them to your clients. So the point of it is you have to act like a reasonably prudent person, a reasonably prudent employer when you hire people. These are the kinds of things that we like to look at when we look at employee backgrounds. And I have to make a point here. The information that you are seeking from employees should be reasonably tailored to the activities they're going to be doing, right? I mean, if it is your receptionist or booking agent, you might not need to run a DMV check for that person, right? If they're going to drive your shuttle bus and you don't have their driving background, criminal background checks, again, you know, if they have access to any of your resources, equipment, things like that. Now, there are some situations where I say, all right, listen, you know, you're in either a hustle to get somebody on board, or, you know, you promise them a job the year before, or, you know, some circumstance comes about where you don't have the time or the moment to actually get all of this done. What you need to do when you hire somebody or when you commit to somebody is have them give you something in writing, a little template that you use that says that they're verifying that the information they're telling you is accurate. That's like a contract, right? And so at some later point in time when the guy can't perform or he doesn't know the skill set or whatever it is, and you go back and verify some of this stuff, you know, he already obligated himself and said that all this was true, and you've got that. That's the basis then upon which you fire the person, because you've got an, you know, a signed contract saying that they're authorizing that this information is true. So it's called an employment attestation. You know, we're going to talk about the internet, what's good, bad, and ugly about it, but you need to use it in your own behalf also. Google these people. See what is on their Facebook. Is this really who you want to have representing your company? What you post about yourself out there and all your funny pictures is discoverable and is a representation of yourself, and it may or may not earn you, lose you, or allow you to keep your job. I do want to talk about drug testing real quickly. The Supreme Court and most of the state courts are upholding drug tests pre-employment. It's a pretty accepted thing these days to do pre-employment drug tests. Two things that I really want to drive home. If you're going to drug test somebody, first and foremost, make it part of the policies and procedures of your business. Right? I mean, you guys should have operating plans, you should have policies and procedures, things like that. Get it into the policies and procedures first that you're going to do pre-employment drug testing, so that there's no question that this person wasn't singled out individually. If it's a new policy or procedure, date it, for goodness sake, so you know that this is where it started and this is why, you know, other people didn't have it in their file, or adopt a policy that goes retro to everybody, but make it a policy or procedure. Get it into your company manual stuff. Second thing is, when you go to drug test somebody, when you actually send them to be drug tested, get them to sign something that says they agree to do it. I mean, a simple little template that says it's, you know, XYZ Raft Company's policy and procedure to do drug testing. I agree to go do it, as a term of applying for employment here. Right? So there's no question that they have voluntarily done this. If you are going to do drug testing post-employment, it's usually going to be as a result of an incident or some malfeasance or some non-performance. Again, you know, if post-employment drug testing is part of your process, you need to have in your policies and procedures when it's triggered. This can't be random stuff, because it can subject you to liability. I mean, if the guy comes back and says he was picking on me and now there's an employment ramification and nobody else has to do this, you've got to be able to go to something objective, which is your policy and procedure, written, which everybody in your company should know about, and have it be in there. I mean, you've got to have something objective to refer back to. And your supervisors need to be trained in that. I mean, they can't just randomly come and say, well, you know, we don't like this guy, or he smelled like dope when he showed up this morning, or whatever it is. We're going to test this guy. Objective, you know, consistent application of the policy and procedure. And in the post-employment situation where the person has already obtained employment, buried within that policy and procedure should be, what are you going to do if they test positive? Because when they test positive and you're sitting there saying, well, we like the guy, we don't like the guy, what are we going to do? It, again, has to be consistent, objective application per person. A lot of people anymore use what are called EAPs. They're EAPs, Employee Assistance Programs. You can just search that and you can make one up for yourself. And it's usually kind of a descending little thing that says, okay, if it's just one violation and it's just a lower level, drug, pot, whatever it is, we'll do X, Y, and Z. If it's more severe or it's related to an incident or it's multiple times, then there are accelerating ramifications for it. So go search those EAPs if you want to. You'll find some good information on that. Big one, drug testing results must be kept separate from the employment file. It cannot be put in the normal employment file. If you put a sealed envelope with your employment file, okay. If you have separate files that have limited access, that cannot just be sitting in an employment file that other administrative personnel can touch. Let's get back to terminating employees. Sometimes it just doesn't go right. They've overstated their qualifications. You can subject yourself to liability, not because you're firing them for the right or wrong reason, but because of how you go about doing it, right? If you terminate them in the wrong way and don't take the appropriate steps, you can be liable for that, and you can get stuck back with the guy, or you can get stuck paying some kind of judgment for wrongful termination, all right? So we take this pretty seriously. So when you terminate people, let's talk about a number of different things, and we're going to try to click through these things. Don't do it in anger. Don't do it right away. Go back and read your policies and procedures. Cool yourself down in some way. Get on the internet. Read a little article on how to terminate an employee the right way. Do whatever it is to cool yourself down. Make sure you follow your policies and procedures. You've heard me say this for years and years and years. Whether it's related to an incident, whether it's related to terminating somebody, if you've got it written down in your policies and procedures, that's because you think that the reasonably prudent person would do it this way. So if you don't do it that way, you're kind of setting yourself up there. So make sure that you follow your policies and procedures. Document the reasons why you're terminating them, obviously. The employee's file should contain a pretty good, accurate history of the relationship between your company and that employee. And if that file is full of just your insurance information and this, that, and whatever, and the date of hire, and then whammo, a termination letter, you're going to be a lot harder to defend, because now it's going to be your word against your paper. Right? So make sure that and we'll talk in just a minute about what really should be in a file. Be truthful. Tell the truth. You guys go through this kind of stuff and you feel like you just want to soften the blow, or you don't really want to get into a confrontation with this person, and so you kind of, fuzz the edges a little bit. You have to be truthful about the thing, because if at a later point in time we're really examining why that happened, and it comes out that, well, honestly, the guy couldn't operate, or he couldn't do X, Y, and Z, and that's why we let him go, or we just didn't have the money. If what you were doing was fibbing to him, now how are we supposed to believe you when we're defending the thing? How is a trier of fact, a judge or jury, supposed to believe that? Pay them at the time of discharge. Most of the state laws give you anywhere from 30 hours to 3 days to fully charge them out. And that means paying their vacation time also. And it means putting them on notice as to how long their insurance is going to last before COBRA kicks in. So you got to do this stuff pretty quick, because you can get yourself into a penalty situation, and experience shows that if they walk out the door with the check, you're actually prepared, there's a far greater sense of finality, and they have no reason to come back and feel in a huff. You've actually taken care of them. If you're going to sit down and terminate somebody, best advice, do it in a neutral environment. Don't do it right in front of everybody. Don't make a big scene out of it. Take them somewhere in some office. Have an observer with you so that you've got a witness. People have asked me a number of times on the observer issue, well, does that mean that I should record it? I am not in favor of recording things because in order to be able to use a recording, you have to tell them that you're recording them, and people generally feel some heightened sense of being put upon when they're recording. So, they just feel like, oh my gosh, I'm not really in favor of that. If you think for some darn reason that that's really the brilliant way to go, you have to notify them that they're being recorded. Stick with what can be proved, obviously. That's like being truthful, right? Be respectful. Be nice. Even if you're terminating the person because they don't really fit into your corporate milieu, or you guys just don't get along, or they're bugging the rest of your employees, or it's just not going to work out. Honestly, they're going to walk out of there without a job. Okay, so let's touch quick on employee files, and then we're going to switch topics. What should be in the employee file? Job description. A lot of you aren't using job descriptions, so we don't know whether the guy was actually doing what they're supposed to be doing, or the gal. Job application and resume, what they give you in the beginning, the information that they're transmitting to you. An offer of employment. A lot of you aren't using written offers of employment. And I know, we've been talking about this stuff for years. I know more paper doesn't feel good to you, but sometime when you're in your off season, you can do templates of this stuff. There should be certain things where, so-and-so is offered the job as, guide level 1 starting on such and such a date. You want to be able to document what date you gave the offer, what date the guy is supposed to start, that kind of stuff. Your W-4s, right, the withholding information. If you have an employee handbook, and you should, because it should have your company policies and procedures in it. If you operate in a state like Colorado where there's equine statutes, whitewater statutes, things like that set the responsibilities of the various levels of guides and operators, things like that. All that stuff should be buried in an employee handbook. Make them sign that they received. People on a seasonal basis are notorious for, okay, that's it, it's August now, the water's down, bye-bye. There's no performance evaluation, and then you hire them back the next year, and that's all well and good while it works out. And truthfully, I understand that in 90% of the time, that is the way that it works out. But if you want to protect your business from liability, if you want to give yourself the freedom to actually terminate people, put some performance evals in there. That should be in the file. Any forms relating to employee benefits, if these guys get to, use your stuff once a month, if they get to, have insurance or sign up for insurance, anything that details the benefits that they're getting from your company. This is really important. A few of you, I hope not many of you go through this, but a few of you have actually had critical incidents with your employees. Do you know how to get a hold of somebody? You may have the guy's cell phone, but where does that go? And for goodness sakes, if he's got it in his pocket while he's out there, right? You need to have some kind of way to contact people. So I'm going to add a couple of other things to put in the employee file. These are more fungible in my mind, but they're things that I want you to think about. Are your other employees complaining about working with this person? If you're getting complaints from other employees, they belong in the employee's file. Always have in the back of your head, who gets to look at this employment file? Is it just a random administrative person? And if it is, do you want to protect sensitive information like that? Have an envelope in there that says, only Duke gets to look at this, or only so-and-so gets to look at this, right? Awards, citations, training certificates, things like that, good stuff. Honestly, I see these employment files every single solitary time we get litigation, because I got to figure out who these people are. And what is so absent from them is what great people they are. And that's so cool when you get a file and there are, customers who call in and say, that guy was so good to me. Put the good stuff in there too. Attendance records, if you have problems with them attending, warnings, disciplinary actions, things like that. Any kind of contracts that have to do with things that you give your employees, like do you give them cell phones? Do you give them, bennies like, well, you can get, the Patagucci stuff at 30% or whatever, and departure documents. If you're going to terminate somebody, use a termination letter. On such and such a day, you fully received your pay. Your COBRA date is X, Y, and Z. The reasons discussed in our exit interview were in the file. When somebody is terminated and it's done, close the file, seal the file, store it. There's no reason for people to be ripping through that file anymore. So 2 things to be careful of in employment files. Medical records, if for some reason or other you've got medical records in the file, you had a positive drug test, the guy had an injury at work, whatever it is, those medical files have to be sealed. They cannot be sitting in the same place as the file. Again, if you just want to, seal an envelope, label it medical, do not touch, not accessible by anybody but so-and-so, fine. But they have to, the HIPAA, the federal law requires us to isolate those records. And the Form I-9s, the INS forms that are required, you cannot have those be laying around in the normal employment file. So just have it put in a little envelope that says, for INIS. They have to be sealed.